Should we start?
Yes, yes.
Okay. Good evening, sir. First of all, thank you so much for joining us and giving us your prestigious time. I know you might be very busy, but thank you so much for that. Uh,
Thank you, Harshida. Thank you for having me.
I'll go through a quick intro. So, we have with us Dr. Lal Kumar, who is an international arbitrator and a mediator based out in Doha, Qatar. He serves as legal advisor and arbitral counsel in an MNC in Doha. Sir is an accredited independent director by the Ministry of Corporate Affairs, Government of India. Sir also holds the post of director, legal affairs in an eco-tourism company having the distinct of the world's largest bright sculptor based in India. Sir has been involved in a very complex ongoing arbitration proceeding recently. Apart from that, Sir is an arbitrator in QICAA Qatar and AIADR Malaysia. We welcome you, sir, and we can progress with the webinar. Thank you so much.
Thank you, Harshida. Thank you for having me. Good evening to all of you. Today, let's discuss what is ODR, Online Dispute Resolution, a way forward for resolution of disputes at the doorstep. I think this is the modern trend and how we can reduce the backlog of cases in the court. So let's first see what is online dispute resolution, or in short, it is known as ODR. In its most basic sense, ODR is the use of, say, technology to resolve disputes. ODR can use technology tools that are powered by AI and machine learning in the form of automated dispute resolution, script-based solution, and curated platforms that cater to the specific categories of disputes. In other words, let's make it simpler. Online dispute resolution, or ODR, is the mechanism to resolve disputes through the use of electronic communications and other information and communication technology, which we all are using it now on a day-to-day basis. So it often uses alternate dispute resolution tools such as, say, negotiation, conciliation, mediation, and arbitration. The concept of ODR is still evolving, not only in India, all over the world. It's still evolving. At a preliminary level, ODR refers to usage of, say, ICT tools, as we said earlier, to enable the parties to resolve their disputes. Now let's see the benefits. The benefits of ODR are manifold. It's cost-effective, convenient, efficient. It allows for customizable process to be developed. I mean, whatever, according to your needs, it can be developed. It can limit unconscious bias that results from human interactions. It can help in dispute avoidance. It can contain disputes. It can finally help in dispute resolution. It can improve the overall legal health of the society. That's the most important thing. It can increase the enforcement of contracts, thereby improve the ease of doing business ranking of India. It can make a big impact in the field of justice delivery system. Online dispute resolution, or ODR, as we discussed, is built on the vision that disputes can be resolved in a seamless manner from anywhere by anybody at a fraction of cost and time. Now let's delve into what the origins lie for ODR. The origins of ODR can be traced to the evolution of the internet in 1990s. The internet was a revolutionary change. So this internet increased online transactions and thereby disputes related to such transactions increased. Naturally. So when something new happens, the new things also come up. We all know. Let's see the first phase. The first phase of ODR. eBay's experiment leads the way. eBay, an online transaction platform, a company known as eBay. The first initiative on ODR projects were launched in 1996 in the University of Massachusetts and the University of Maryland in the US. In the late 1990s, with the expansion of the internet and the evolution of e-commerce, a robust system was required to address the disputes originating from commercial activities and the internet. So ODR offered a solution to this problem. Around the same time, ODR was pioneered in a few early e-commerce entities in US. In 1999, eBay started a pilot project. This is, just remember, this is the first time they were starting to provide online mediation facilities for disputes arising between buyers and sellers on its platform. The pilot project handled 200 disputes in a 2-week period. By far the largest number of disputes ever handled online. It prompted eBay to include ODR as an option to its buyers and sellers in the event a transaction was unsuccessful. Initially, eBay's dispute resolution process was contracted out to an internet startup company known as Squarepay. And several years later, it was taken over by eBay itself. The number of disputes handled by eBay grew steadily over the next decades, and by 2010, eBay was handling over 60 million disputes per year through the ODR platform. Just imagine the growth, the volume of growth of dispute resolution through ODR means. Now let's see what happened in the second phase. So this we discussed about the first phase, about only one company known as eBay. In second phase, the growth of ODR startups. The success of eBay ODR process and the rapid growth of the internet kickstarted the evolution of ODR, leading to the boom of ODR platforms. There were up to 21 new ODR programs that were launched in the year 1999 from only 9 in the previous year. By 2004, the number had reached 115. Even the Internet Corporation for Assigned Names and Numbers, ICANN, instituted the domain name dispute resolution. It started off as an offline process, but eventually became increasingly online. However, the most of these startups failed. Only a few successful platforms such as CyberSettle, SmartSettle, and Mediation Room were able to make a sizable impact in the dispute resolution ecosystem. And there is a third phase, adoption by the government and judiciary. The success of a few of these private ODR platforms drew the interest of the government towards this emerging addition to the dispute resolution ecosystem. One of the first steps towards this adoption was taken in 2004 when the city of New York adopted an ODR system developed by CyberSettle to clear their backlog and expedite the settlement of personal injury claims. This resulted in reduction of settlement time by 85% and an impressive 66% settlement rate within 30 days of submission of the dispute. recognizing the efficiency of ODR, some government also undertook initiative to integrate ODR into their judicial structure. Some of the most notable examples of court-annexed ODR include Rechtwijzer 2.0 in Netherlands, Civil Resolution Tribunal in British Columbia, Canada, Money Claim Online in UK, and the New Mexico Courts Online Dispute Resolution Center in the USA. The successful integration and co-option of ODR across the world has ultimately led to the development of few models of ODR, all of which have been running in parallel across the globe. They are in-house private ODR platforms. It means the platforms run by individual businesses. Private ODR platforms or service providers catering the different categories of disputes and multiple modes of resolution. Government-run or state-sponsored ODR programs and platforms. Now let's see, this all happened apart from the normal traditional judicial delivery system in the court. So it started a court-annexed ODR system. The ODR ecosystem gained momentum during the COVID-19 pandemic. We all have experienced how difficult it was during the COVID-19. But there was an opportunity in that. The lockdown triggered the judiciary across the globe to resort to the potential of ODR, integrating the best available technology globally. The use of meeting platforms such as Zoom, Google Meet, Microsoft Teams, WebEx, etc. were used for online dispute resolution. Virtual hearing at the national courts has become a norm. Even now it's continuing, we know that. An international institution that is worthy of mention is that National Center for Technology and Dispute Resolution, NCTDR. University of Massachusetts, that University of Massachusetts that has actually started this NCTDR. It has been leading the ODR movement with constant efforts to develop the process and system that forms the basis of ODR. In 2017, fellows of NCTDR created the International Council for Online Dispute Resolution, ICODR, to promote ODR and promulgate standards and best practices for ODR. ICODR has since published ethical standards for design, structure, practices, and implementation of ODR, ODR training standards, video mediation guidelines, and video arbitration guidelines to guide the development of ODR worldwide. Though these guidelines are not binding, it's all known as soft laws. They encourage ODR platforms and ODR service providers to achieve a set of aspirational standards and best practices to follow. Now let's see, getting India ODR ready. So what we need is building a sufficient capacity, and infrastructure is the key to popularize ODR in India. ODR is in its nascent stages of development in India. It is important that the governance framework encourages the growth of innovation, both within the government and in the private sector. Now let's look into the growth of ODR in India. It has not started during the COVID-19. It started even before that. So in 2006, National Internet Exchange of India adopted .in domain name dispute resolution policy, which provided online dispute resolution for internet-related, internet IP address-related cases. In 2011, Chennai-based Chennai, Chennai hosted 10th Annual International Forum on Dispute Resolution. In 2016, the Online Consumer Mediation Center, OCMC, was established at the National Law School of India University, Bengaluru, under the aegis of Ministry of Consumer Affairs, Government of India. In 2017, Ministry of Law and Justice issued a statement to urge the government agencies to resolve disputes through online arbitration. In 2018, Ministry of MSME launched Samadhan portal to address delay of payment of disputes involving micro and small enterprises. In February 2019, EADR challenge was launched to identify the support of ODR startups. In May 2019, a report of the high-level committee on deepening of digital payments established by RBI recommended an ODR system for resolution of digital payment disputes. In February 2020, Government of India launched Vivad Se Vishwas scheme for efficient resolution of tax disputes through ODR. In July 2020, Chhattisgarh conducted first virtual Lok Adalat and provided conciliation services through video conferencing. July 2020, Niti Aayog established a committee under the chairmanship of Justice retired A.K. Sikri to broad-base the views of ODR in India. In July 2020, again, the Vidhi Center for Legal Policy published a report on mainstreaming ODR in India. In September 2020, Department-related Parliamentary Standing Committee on Personal Public Grievances, Law and Justice, in their report, called for introduction of technology in arbitration and conciliation process. So these are the, the way, if we look back, how India was evolving in the ODR. Then after these were the small steps. Then India has taken the real plunge into the ODR ecosystem during the pandemic, COVID-19, as we said earlier. As a result, a step forward this direction was taken by Niti Aayog in collaboration with the civil society and other organizations. Conducted a virtual consultation titled Catalyzing Online Dispute Resolution in India on 6th June 2020. The main objective was to bring together key stakeholders to discuss the manner in which ODR can be introduced in India. Senior judges of the Supreme Court, secretaries from key government ministries, industrialists, legal experts, and general counsels of leading enterprises were in attendance. There was a common consensus amongst all the stakeholders that the key to ODR development in India was through collaboration between the various stakeholders from the government to the industry. A second session was held on 8th August 2020 by the Niti Aayog, which was titled Unlocking Online Dispute Resolution to Enhance the Ease of Doing Business. To consolidate the idea gained during these consultations and to create an effective implementation framework for ODR in India, a committee was constituted, as we said earlier, by Niti Aayog under the chairmanship of Honorable Justice retired A.K. Sikri. To popularize ODR, we need to create a facilitative ecosystem with the necessary changes in our data protection laws. Amendment to existing commercial and other special laws to make it ready to support the ODR system. Digitization of process of notarization and payment of stamp duties are to be made available. Self-regulatory organizations, SROs in short, are to be created for ensuring compliance of the principles such as design principles for ODR platforms, set of ethical principles for ODR centers, and third-party neutrals who are the facilitators and stakeholders of ODR system. Judicial preparedness and acceptance. That is what is the most important thing. To popularize ODR, there needs to be solid preparedness on the part of all stakeholders. Judiciary through increased reliance on ICT in judicial process and explicit recognition of the need for technology to address the challenges of the judicial system give legitimacy to similar efforts in ADR mechanisms. E-Courts Mission Mod projects. Under this project, E-Committee for monitoring the use of technology and administrative reforms in the Indian judiciary continues to advocate and work towards greater reliance on ICT tools in the justice delivery process. Some of the key success of the E-Court projects are creation of National Judicial Data Grid, NJDJ in short, and establishment of a unified case information system, unified CAS. This has streamlined judicial process through litigant centers, services like electronic cost list, e-filing, e-payments, and easy access to case status and daily orders. This is what we see in the courts. The new generation, the students can see that this is happening. But when we started, there was nothing. Everything was manually done. E-filing of cases. E-filing of cases have become a norm for the district courts, high courts, Supreme Courts, and tribunals. Now, electronic signature. Considering the low availability of the hardware cryptographic token for e-signature on PDF documents, the e-filing portal launched under the E-Courts Mission project also provide a facility for e-signing. Integration of artificial intelligence. The Supreme Court has harnessed the potential of artificial intelligence through the development of SUVAS, Supreme Court Vidik Anuvad software. This AI-powered software has the capability of translating judgments, orders, and judicial documents from English to 9 vernacular language scripts, mainly Marathi, Hindi, Kannada, Tamil, Telugu, Punjabi, Gujarati, Malayalam, and Bengali, and vice versa. Now let's see why we need to adopt ODR. There has to be a reason. Otherwise, our traditional court is enough, right? So let's see. Government litigation contributes to about 46% of all litigation in the country. Means the largest litigator is the government itself. As per the data available with the Law Ministry as on July 2023, Government of India is party to 6.3 lakhs cases and has spent 272 crores on litigation for the past 5 years. According to the Legal Information Management and Briefing System, in short, it is known as LINS portal, as on 6th May 2024. Now, today is 11th. As on 6th May 2024, the government has 7,10,8 883 cases pending in different courts across the country. I mean, this is all the government cases. Government is the party. Given the numbers, it's worth considering any small impact the ODR may have on government litigation. Though the central government had set up a high-powered committee way back in 1991 with an objective to prevent litigation by offering in-house conciliation services, no tangible results were obtained. If the government of India and its interdepartmental arms strategize and integrate ODR to resolve their disputes, it can have dual benefits. One, it will pave the way for ODR to be used in all disputes where government is one of the parties. Two, the government's adoption of ODR will boost confidence in ODR process and the outcomes, and in turn it will encourage private parties to readily opt for ODR as a preferred mode of dispute resolution. During the pandemic, COVID-19, the Parliamentary Standing Committee report on virtual courts noted that virtualization of proceedings would help overcome major challenges in justice delivery, such as, say, distance, delays, and cost. It also will increase the access to justice and result in an affordable and citizen-friendly legal system. The committee also recommended that the concept of virtual courts may be extended to arbitration and conciliation to make justice delivery efficient and cost-effective. One of the recent steps by UN is bringing the United Nations Convention on International Settlement Agreements resulting from mediation. Commonly, it is known as Singapore Convention. The convention came into force in India on 12 September 2020. It allows for direct enforcement of mediated settlement agreements and enables swift enforcement of settlement agreement arising from international mediation. Now, the Mediation Act 2023. Following the Singapore Convention, India has enacted a mediation law. The main objective of the law is to promote and facilitate mediation, especially institutional mediation for resolution of disputes, commercial or otherwise, enforce mediated settlement agreements, provide for a body for registration of mediators, to encourage community mediation and to make online mediation as acceptable and cost-effective process and for matters connected therewith or incidental thereto. It may facilitate two aspects, among other things. One, the Mediation Act provides for a voluntary option to parties to mediate any civil and commercial disputes before instituting any legal proceedings in the court. Unfortunately, it has not been made a compulsory one. The initial drafting was a compulsory mode was there, but subsequently the parliamentary committee did not agree to that. So then when the act came up, so it is as a voluntary option to parties. We hope that over a period of time, it can become a mandatory mediation. Secondly, in today's digital times, the Mediation Act institutionalizes online mediation. Mediation conducted by use of electronic form or computer network, but not limited to an encrypted electronic mail service, secure chat rooms, or conferencing by video or audio mode, or both. However, unfortunately, the Mediation Act does not deal with the international mediation. So that is also a shortcoming in the Mediation Act. I mean, we are not talking about the international mediation, and India is yet to ratify the convention. So maybe that may be one of the reasons. ODR is ODR is an idea whose time has come now. But in order to become mainstream, it needs change makers, those who will be its champions and ambassadors. ODR owes a debt of gratitude to those who tirelessly championed ADR as an effective model of dispute resolution. It was ADR that made the idea of resolving disputes outside the courtroom acceptable. As the trend caught on, some parts of the world revived and integrated ADR-like processes that had existed in traditional system. When ODR eventually began to take shape, it borrowed its core tenets from the ADR, while simultaneously mutating to become the next evolutionary step in dispute resolution. Recent years of digitalization paved a favorable precondition for the advent of ODR, such as an exceptional increase in digital penetration amongst all classes of people. 2. The vocal support of higher judiciary. 3. The steps taken by the RBI and NPCI to incorporate ODR in areas such as digital payments. A robust ODR ecosystem in India will 1. Have both high potential to reduce the load of courts by resolving high volumes of disputes outside the courts. 2. Allow access to justice and ease of doing business by making dispute resolution cheaper, quicker, and most importantly, equally credible as conventional methods. 3. Increase trust in business and also within the society by prioritizing collaborative resolution. As ODR absorbs the bulk of civil cases, the judiciary gets freed up to focus on those matters that cannot and should not be moved out of our courtrooms. In other words, ODR ensures that the judiciary does not have to divert its attention from the most important disputes facing the nation. The key elements of ODR technology is remote service, dispute resolution at your doorstep. It makes itself available whenever you want and wherever you are. Artificial intelligence, AI or ML. Over a time, one can expect an ODR software, AI or ML capabilities to be able to solve low value, minor and non-critical disputes on its own. It will also be able to serve human professionals in more complex cases. Driven by data, ODR software and solution providers can learn from every case and make incremental improvements for the future.